Well, those are the big headlines of this hour, and this is a show where our team at CNBC-TV18 gets you all the top stories of the day. I'm Surabhi Upadhyay. You're watching Reporter's Diary. It's a big relief for Aberdeen, and that's the news that's coming in from the Bombay High Court. We also have Mr. Dinesh Kanabar joining us on the phone line to take us through what perhaps this could mean. The understanding right now is the Bombay High Court has issued a stay order on that MAT notice which was levied on Aberdeen and several other FIIs over the minimum alternate tax. Mr. Kanabar, thanks for being with us this evening, sir. What do you make of these developments? We don't know what exactly the court has said, but we're given to understand that a stay has been issued.
Yes, we are all waiting for the interim order, and I have not seen it, so I'm commenting only on the basis of what I have heard. But from what I am given to understand, the Bombay High Court heard the matter, and one of the objections before the Bombay High Court was that instead of passing a draft order, as is required under Section 144C of the Income Tax Act, a final order was served on Aberdeen. Just to explain that simply, in the case of a foreign company or where there is a transfer pricing adjustment, the law mandates that a tax officer would have to pass a draft order. And unless the SSE chooses not to object to that within 30 days, a final order cannot be passed because the draft order can be challenged before a dispute resolution panel. From what I'm given to understand, apparently that process was not followed in the case of Aberdeen. And on this technical issue, Bombay High Court has granted a stay to Aberdeen.
Mr. Kanabar, looking at the way the situation is evolving, of course, we did hear from then the IT department as well, and they seem to be watering down their earlier hard stance by saying that any kind of disputes that are arising or any kind of claims that are arising against these notices will be settled in 1 month itself. How do you see some of these, points of conflicts playing out?
I really don't know what to make of that earlier statement and the notification which came out to say that all the disputes have to be resolved within a month. If the stand of the tax office is that FIIs, although they do not have a presence in India, although they do not maintain books of accounts in India, are liable to MAT tax. And again, what I'm given to understand is that the stance that has been taken practically is that these provisions apply only to those FIIs which come from other than countries where under the tax treaty capital gains are shielded, so other than Mauritius and Singapore. If that be the situation, then whether they pass the orders in a month or whatever, it's not going to resolve the matter. It's only going to mean that more demands are going to get created. The interesting thing will be to see that now that the Bombay High Court has granted this stay in this one matter, and then there are a few other matters which are before the Bombay High Court. If the Bombay High Court does grant a stay in all of these matters, whether the tax office will wait for these matters to get resolved, either at the Supreme Court, where the cancelled matter is coming up for hearing out of turn, or by the Bombay High Court, and not do any precipitative action until these matters are decided. It'll be interesting to see how does the tax office treat the whole matter.
Sure. Mr. Kanabar, sir, do stay on the line with us. We also have Mr. Parikh now joining in, partner BMR Advisors. Mr. Parikh, good evening. What is your reading? As we've been discussing with Mr. Kanabar as well, don't have exact details of what the court has said, but as Mr. Kanabar is pointing out, it perhaps has to do with the technicality that the taxman went ahead and issued a final order instead of issuing a draft order, which is why perhaps Aberdeen has been able to secure the stay.
So I concur with Dinesh's observations. That is also my understanding that unlike most other FIIs or unlike all other FIIs, I guess Aberdeen seems to have been issued a final assessment order instead of a draft assessment order, and that is what is challenged in the High Court. And while I haven't seen the order of the High Court either. It is possible that what the High Court has done is effectively stayed the final order and might direct the tax department to allow for Aberdeen to be able to access the remedies that it should have been able to access had a draft order been issued rather than a final order. So I don't know that this in any way represents a particularly definitive or even a sort of a line of thought, preliminary thought from the High Court on the principal issue that we are otherwise dealing with.
Before we carry on this conversation, for the benefit of our viewers, I just want to place some facts on record. From the understanding that we have, the tax demand that was raised with respect to Aberdeen was just around $50,000, and that seems to be a lot lesser or lower than the kind of notices that were sent to several other FIIs. Mr. Hugh Young, Managing Director, Asia for Aberdeen, went on record to say, and I quote, "In our case, the demand is small, but it is the principle of the thing which we are fighting for." Of course, Aberdeen investing over $10 billion in India in various investments. Mr. Parikh, let me come back to you now. To what extent do you think some of these, cases will hold water, or what are the grounds on which some of these big legal battles will be fought? Because the government has been very clear saying that whatever relief we are offering, it is prospective in nature, which is this financial year onwards, and prior cases have to be dealt with according to the procedure of the law, the course of the law.
Yeah, so I think that, so the issue really fundamentally is whether MAT provisions apply to foreign companies generally, and if they do apply to foreign companies, whether they apply to all forms of foreign companies or only to foreign companies that might have a place of business in India and therefore are required to maintain accounts in accordance with the Companies Act of India. Now, to the extent that FIIs don't have a place of business in India and don't have, and therefore do not have any requirement to maintain books of accounts, the way that MAT provisions have been interpreted historically is that those kinds of companies are not liable to MAT, and so fundamentally the issue that will be discussed and on which the court will rule will be whether MAT provisions apply in such situations at all or not, and really the issue is limited to that point. While the government has prospectively amended the law to say that MAT provisions will not apply to those entities, I think the law as it stood before reasonably suggests that MAT should not have applied to FIIs in any case.
Mr. Kanabar, as we wind up this conversation, your sense on a point that you raised earlier, the Castleton case is already out in the Supreme Court, and the finance minister made a reference to that case, not naming Castleton, but drawing a reference from that outstanding, case in the Supreme Court. Will that have any bearing on the manner in which some of these disputes which have been, filed with the Bombay High Court, in the manner in which they play out in the days to come?
Oh, absolutely. The Castleton matter is directly on the issue as to whether FIIs who do not have a presence in India are or are not required to pay MAT tax. And therefore, if given the fact that the Castleton judgment has been, or the matter has been taken for out-of-turn hearing, whatever is the ruling of the Supreme Court in that matter will be the law of the land. And therefore, hopefully, if that comes sooner rather than later, then all the other writ petitions and everything else will become infructuous, because that will be the law of the land applicable for the period prior to the amendment coming into force.
All right, Mr. Kanabar, Mr. Parikh, we'll leave it there. Thanks so much for running us through your understanding of the way things stand right now. So some relief coming in for Aberdeen, the Bombay High Court issuing a stay on that MAT notice that had been served on the investor. Time for a break, but coming up on the other side.